dinner parties just invite the right people.
Now more live coverage of the American Bar Association's National Security Law Conference. A discussion getting underway now on the relationship between Congress and the intelligence community. Live coverage on C-SPAN.
Must the president comply? Question mark. And we're going to have a conversation about the constitutional and policy issues raised by those two questions. And very little reaction really when this group hears those questions, because we've been debating them a lot over the last several months, certainly. But I have to share with you, a few days ago I was with a couple of gentlemen from the Czech Republic, and I was telling them about this conference, and I was telling them that I was going to be moderating a panel on Friday afternoon at which we were going to talk about whether the president needed to abide by laws that were passed by Congress and signed by the president. And they laughed. And I said, no, seriously, this is a very serious discussion that we need to have in our country and that we've been having that raises some very serious issues about the separation of powers and the role of the three branches and particularly in the role of those branches in a time of crisis. All of us have been reminded, and I certainly have, and a lot of us in this room, to pull out copies, our old copies from law school, of the Steele seizure case. And today's discussion, I think, we're going to be operating and discussing that third category of Justice Jackson's concurring opinion. You all will recall, of course, the Steele seizure case where President Truman, during the Korean War, seized the steel mills and argued that that was pursuant to his commander-in-chief authority, despite the fact that it was in contravention of a law that Congress had passed, regulating the conditions and the circumstances and the procedures under which the president could take such action. And the court rejected the president's claim that this was fundamental to his war authorities under the Constitution and commander-in-chief and executive authorities under the Constitution. But the majority opinion is actually also very well worth reading. But the opinion that most folks remember and seize upon, and that we've been reminded of so frequently in the last couple of years, is the concurring opinion by Justice Jackson. And Justice Jackson talks about this tension and between the president and the Congress and the ways in which they interact. And he sets forth three categories that provide kind of a framework for thinking about these issues. And the first category, of course, is where the president is acting with the full scope of the president's authority, and Congress has also authorized the action. And so, and his action is in concert with what the Congress has authorized. And Justice Jackson says that's where the president's power is at its peak. That's where the president is strongest in his action, which I actually think is kind of ironic, since we've sort of heard a great deal, certainly in the last few years, about the importance of the powerful president to be able to act unilaterally. But Justice Jackson said that's where, from a constitutional sense, that's where the president's power is greatest. The second category is where the president acts and Congress has not acted on that, in that area. There's no law that applies, no statutory law that applies, and the president has taken some action. Then it's simply a question of, does the president have the constitutional authority to take that action? And Justice Jackson describes that as sort of a gray area. You have to look at the president's constitutional authority and interpret that. The third category is where the president has acted in contravention of the explicit or implied will of Congress. And Justice Jackson says that's where the president's authority and power is at its weakest. Interestingly, though, Justice Jackson does not say that the president cannot act in that third category. What Justice Jackson says is that the president, you must find that the president has exclusive authority in that area, that Congress is constitutionally prohibited from passing a statute in that area, from acting in that area, from regulating that area, and that the president has exclusive authority. I think this has often been misinterpreted to say whether the president has inherent authority. But what Justice Jackson says is the president has to have the exclusive authority in that area if he's going to act in a way that's in contravention of Congress. So that's the area in which we're going to talk about mostly today, and we're going to mix up the formats here. We're going to have two folks present, I think, opposite answers to those questions. I think we'll have a yes, yes, and a no, no. And they will set a framework for the discussion, and then we'll call on, those are both individuals who are now academics, and then we'll call on sort of our practitioners to react, and we'll have a moderated discussion for a bit, and then we'll get you guys into it. So we're going to start today hearing from Lou Fisher, or did we decide Bob Turner would go first? Okay, we're going to start today hearing from Bob Turner. And Bob Turner is co-founder and associate director of the Center for National Security Law at the University of Virginia School of Law. He has also been a practitioner of many years, starting as a national security advisor for a U.S. Senator, assistant to the Undersecretary of Defense for Policy. He was counsel to the PIFIAB, to the President's Intelligence Oversight Board, Principal Deputy Assistant Secretary of State for Legislative Affairs, and the first president of the United States Institute for Peace. Perhaps most significantly, he was also former chairman of the ABA Standing Committee on Law and National Security. After Bob speaks, we are going to hear from Lou Fisher, and Lou Fisher is a senior expert and specialist in constitutional law at the Library of Congress's Law Library, where he came after a very long and distinguished career in the Congressional Research Service, where he thought about and wrote about these issues extensively for over 30 years, including a stint as the research director for the Iran-Contra Commission, and wrote much of that report. He is frequently called upon to testify in front of Congress. He has written numerous books and won numerous awards, and I think we'll get off to a great start with these two speakers, and I'll introduce the others after that.
Thank you very much, Suzanne, and welcome. It's a great pleasure to be here. This series started 17 years ago when I chaired the committee, and I had very little to do with the idea. It was Maury Liebman's idea, but I continue to take pride as at least having been present at the creation, if you will, because it's a wonderful program each year. I'm not going to talk about steel seizure, in part because it has nothing to do with foreign affairs. I'll explain that during the Q&A period if somebody will be kind enough to ask me what I think of steel seizure. What I want to talk about is intelligence and the views of the Founding Fathers and the President's authority in this area, which when we're talking about foreign intelligence, I believe is essentially an exclusive power. One of the key themes we hear from presidential critics are that this is a nation governed by the rule of law, and not even the President is above the law. And of course, that's correct. But America has a hierarchy of laws with the Constitution at the top. And if the people through the Constitution have given certain powers to the President, Congress cannot, by a mere statute like FISA, take those powers away. As Chief Justice John Marshall told us in 1802 in Marbury versus Madison, an act of the legislature repugnant to the Constitution is void. Using the Department of Foreign Affairs, what we now call the Department of State, as an example, Marshall explained that, I quote, "By the Constitution of the United States, the President is invested with certain important political powers in the exercise of which he is to use his own discretion and is accountable only to his country and his political character and to his own conscience. And whatever opinion may be entertained of the manner in which executive discretion may be used, still there exists and can exist no power to control that discretion." Time will not permit a full discussion of this issue. George Washington, James Madison, Thomas Jefferson, Alexander Hamilton, John Jay, and many other of our founding fathers agreed that Article 2, Section 1 of our Constitution, which grants to the President, quote, "the executive power of the United States," carried with it the control of foreign affairs, diplomacy, intelligence, and the conduct of war, the exclusive control, save for those specific exceptions vested in the Senate or in the Congress. And the view was that those exceptions, as exceptions to a general grant, were to be construed strictly. This was based on the understanding of the meaning of executive power as defined by John Locke and Montesquieu and Blackstone, the political Bibles of the Constitution. In Federalist number 64, John Jay, our most experienced expert on foreign affairs, explained that Congress could not be trusted to keep secrets, a very common theme in those days, and thus the Constitution had left the President, and I quote, able to manage the business of intelligence as prudence might suggest. Congress was not supposed to be given secrets. It could not be trusted to keep them. The first appropriation for foreign affairs enacted in 1790 reflected congressional deference in this area. And this was language used for many, many years. It provided, and I quote, the President shall account specifically for all such expenditures of the said money as in his judgment may be made public, and also for the amount of such expenditures as he may think it advisable not to specify, and cause a regular statement and account thereof to be laid before Congress annually. In 1804, Thomas Jefferson wrote a letter to Secretary of the Treasury Albert Gallatin in which he explained, and I quote, the Constitution has made the executive the organ for managing our intercourse with foreign nations. The executive being thus charged with foreign intercourse, no law has undertaken to prescribe its specific duties. From the origin of the present government to this day, that is for 15 years, from Washington through Adams to Jefferson, it has been the uniform opinion and practice that the whole foreign fund was placed by the legislature on the footing of a contingent fund in which they undertake no specifications but leave the whole to the discretion of the President. On the issue of congressional controlling and Congress controlling intelligence, in an 1818 floor debate in the House of Representatives, the great Henry Clay said it would be improper for Congress to inquire into expenditures from the President's Secret Service Fund. And that account, by the way, at one point totaled 14% of the federal budget. This view continued until the Vietnam War, when we seem to have had a hard disk crash and everyone forgot about the Executive Power Clause. To give you just one example, in 1959, Senate Foreign Relations Committee Chairman J. William Fulbright explained in a speech at Cornell Law School, and I quote, the preeminent responsibility of the President for the formulation and conduct of American foreign policy is clear and unalterable. He has, as Alexander Hamilton defined it, all powers in international affairs which the Constitution does not vest elsewhere in clear terms. Now, I want to emphasize I'm talking about foreign intelligence, not domestic intelligence. If we're not talking about a foreign power, this power does not apply. Certainly Congress can regulate purely domestic activities, and the Supreme Court told us in the 1972 Keith case that wiretapping and surveillance of or electronic surveillance of a purely domestic national security threat required a warrant. However, particularly in an authorized war, if we are monitoring Al-Qaeda in Pakistan or Afghanistan and they start communicating with people in this country, that's still collecting foreign intelligence. No warrant is required, and the President controls that area. In 1968, when Congress passed the Omnibus Crime Control and Safe Streets Act, the first wiretap law, it expressly provided, and I quote, nothing contained in this chapter shall limit the constitutional power of the President to obtain foreign intelligence information deemed essential to the security of the United States. When the FISA, I worked in the Senate when FISA came up, and when it was pending before us, the Carter administration Attorney General Griffin Bell came before the House Intelligence Committee and told them, this bill can't take away the President's power under the Constitution. But he said, nevertheless, that's not a problem because it'll work because President Carter is willing to agree to this arrangement. The Carter administration, I would add, like every administration back to Franklin D. Roosevelt, engaged in warrantless foreign intelligence wiretaps on the theory that there was a foreign intelligence exception to the Fourth Amendment warrant requirement. In the Trung case, for example, the Carter administration entered a man's home, bugged his telephone, planted hidden microphones, and even installed a video camera in his office to monitor his activities for more than 300 days without even talking with a federal judge. And when this was challenged in court in the Trung case, the district court said there is a foreign intelligence exception to the Fourth Amendment warrant requirement. The Court of Appeals agreed. When FISA was enacted in '78, Congress created not only the FISA court that we've heard about, but also an appellate court made up of federal Court of Appeals judges called the FISA Court of Review. And in 2002, in a unanimous opinion, that court said, and I quote, "The trunk court is that all the other courts to have decided the issue held the president did have inherent authority to conduct warrantless searches to obtain foreign intelligence information." And it went on to say, "We take for granted the president does have that authority, and assuming that is so, FISA could not encroach on the president's constitutional power." Now, this is a unanimous decision from the court set up by Congress to oversee FISA. Now, the Supreme Court, to be sure, has never decided the issue. But in two opinions involving wiretaps, it expressly eliminated or accepted foreign intelligence wiretaps from its opinion. First in the Katz case in a footnote, and then in the Keith case repeatedly, Justice Powell, who was one of the founders of this committee, declared, this does not apply to foreign intelligence wiretaps, to wiretaps involving foreign powers or their agents in this country. On 4 other occasions, where courts of appeals held there is this exception to the Fourth Amendment for foreign intelligence, all of those cases were appealed to the Supreme Court, and the Supreme Court did not take one of them for consideration, because usually the court will not take up a case unless either the circuits are split or the court believes the circuits have got the answer wrong. I'm running out of time, so I won't spend a lot of time talking about Supreme Court cases holding that there is not a requirement for probable cause and a warrant for every search or seizure. Outside of law enforcement, there are a number of exceptions, long-standing exceptions, where the Supreme Court says you're allowed to search. Classic example is every time you get on an airplane, unless you've got a private plane, you get searched and your baggage gets searched. That is a Fourth Amendment search, and the courts have balanced. What the court does in these cases, what it calls special needs cases where safety is involved, it balances the privacy interest against the governmental interest, and the Supreme Court has repeatedly held, as it did in Hague versus Agee, no governmental interest is more compelling than the security of the nation. Indeed, Judge Henry Friendly of the Second Circuit, in one of the landmark cases on this, said the risk of the hundreds of lives being lost and thousands or millions of dollars being lost in an airplane hijacking or destruction is so great that the search is reasonable, even though there is no individualized suspicion. I don't find many people who say that listening in when Al-Qaeda calls someone in this country is unreasonable. What I find is people say, in fact, I don't find anybody saying, and if Al-Qaeda calls someone in this country, we certainly ought to unplug our headphones so we can't hear it in the interest of privacy. I think that's silly. I've testified before the House and Senate Judiciary Committees in the last couple of years several times. I haven't found a single member who says it's unreasonable to listen to these calls or they should be stopped. What they say is the rule of law has to prevail. We've told the president how he has to do this, and he must do that. And the answer to that, I think, is very simple. Every court to consider this issue, save for one district court that got overturned almost immediately a couple of years ago, all of the circuit courts have held the president has this power. The Federalist Papers told us he has this power. The Founding Fathers told us he has this power, and it's Congress that's breaking the law. And I just close with one final point, because it's one of Lou Fisher's favorite points, and he's my source for it, that we have a serious problem of congressional law breaking. To give you one example, in 1976, when a Senate staffer, I wrote a long speech for my senator, went to Congressional Record complete with, I think, 30 footnotes, arguing that legislative vetoes are unconstitutional. In 1983, the Supreme Court agreed with that for precisely the same reasons and held legislative vetoes to be unconstitutional. Lou will confirm that since that time, not only has Congress not gone back and removed the legislative vetoes that existed, it has passed more than 500 new legislative vetoes, effectively giving the Supreme Court half a peace sign, if you will. We have a serious problem of law breaking. We have a serious problem of legislative law breaking. Most of the signing statements that we hear about are tied into these legislative vetoes, although other issues as well. And we need to get the Constitution back in order. If you want, during Q&A, we can talk about the harm done by some of these laws, because FISA contributed significantly to the success of the 9/11 attacks. Thank you.
I've been to this conference many times. I have friends here who go back 25, 30 years, and I think I always come to this conference, and this is the gold star as to how a conference should be run. So for those who conceived of the conference today and organized it and pulled it off, my congratulations to you. The question for us, can Congress regulate intelligence? Must the President comply? Depends a lot on whether Congress has an understanding of itself as a separate branch with a duty to exercise checks and balances. I came to Congress in 1970 in the Nixon years when there were fistfights every day of the week, and Congress had at that time a number of members in the House and the Senate who I regard as institutionalists, who cared about their duties. They did not have to think like the White House. They did not have to obey what the executive branch wanted to do. And today there are very, very few people like that I know. I wrote a book in the year 2000 called Congressional Abdication on War and Spending, the two basic prerogatives of Congress, and members have been throwing them away for a long time. And yesterday at lunch we heard from Jim Cooper, who said that on his committee he knows of colleagues who spend upwards of 75% of their time raising money. I've been less concerned about fundraising for any types of corruption in Congress, but more about the lack of time that's available to police your own institution and to get up to speed on subject matters. I always forget that these are my personal views, I hope you know, and no one else's. I didn't know what Bob was going to say today, but I, in advance, put down as my first topic secrecy, and sure enough, Bob gets there. Bob always does a very good job of explaining what William Blackstone and John Locke and others held about executive power and the executive having exclusive control over foreign affairs and war powers and external affairs. Absolutely true. What Bob doesn't say is that the framers looked at that model and repudiated it. Everything that Blackstone said about executive prerogatives and executive affairs, all of those prerogatives were withheld from the President. They're either given exclusively to Congress in Article 1, or they are shared between the President and the Senate, as with making treaties and appointing ambassadors. So the model that infused the British monarch was thought about by the framers, rejected by the framers. Bob mentions John Jay in the Federalist Papers. He doesn't mention John Jay in Federalist Number 4, where Jay explained not only did we withhold the war power from the President, but we don't trust executives. And we've looked at history, and executives regularly go to war not for the national interest, but for some private interest, some personal interest, some family interest, and a disaster for the country, both in lives lost and treasure lost. So the framers rejected that. And as far as any sort of exclusive power of the President in foreign affairs that Bob talks about, in 1801, Chief Justice John Marshall, in a war powers case, the quasi-war with France, said that we look solely to Congress for a source of authority. In 1804, again, a quasi-war issue, in Little v. Bareem case, there's a clash between what Congress provided by statute and what President John Adams did by proclamation, and John Marshall again saying there's no question that in such a conflict the statute prevails, the proclamation does not. Some people look to the prize cases of 1863 as a recognition by the Supreme Court that the President has some sort of exclusive power over war. The court, Justice Greer, made it very, very clear that we're talking here about a domestic insurrection. We're not talking about anything external. And Justice Greer said if you're ever talking about the power to take the country from a state of peace to a state of war against another country, that's exclusively for Congress. And the attorney for the White House, Richard Henry Dana Jr., arguing the case for President Lincoln, said exactly the same thing during oral argument. I want to get to secrecy because Congress cannot assert itself much if it thinks that the executive branch has a right to hold matters in secret, and of course it would have the upper hand, and you know how difficult it is for members of Congress and committees to get access to this. I just want to say that although secrecy is essential in many operations, secrecy also can weaken national security. And I'll give you some examples. One was Pearl Harbor, where November 27, 1941, George Marshall sends out a confidential message to those in the Pacific, Pearl Harbor in the Philippines and others, warning of, quote, hostile action by the Japanese. They had broken the diplomatic code. They knew that that was to an end. George Marshall said the Japanese could attack, quote, at any moment. Then he says, defensive measures should not alarm civil population or disclose intent. And he said, limit dissemination of this highly secret information to minimal essential officers. And so you have a message here that's mixed, it's secret, and you have, I think, bad judgment by the military leaders as to whether you should alarm the civil population or prepare, and we were unprepared. We were at the lowest level, not only in Pearl Harbor, but the planes were on the ground in the Philippines. Gulf of Tonkin, again, secrecy. August 64, there's an attack on an American warship. 2 days later, there's a reported attack again. There were doubts as to whether there was a second attack, but President Lyndon Johnson said that there was, and it was unprovoked. That was not true. We had been helping the South Vietnamese, so there was nothing unprovoked about what the North Vietnamese did. There's always doubt as to what happened to that second. Anyway, Congress passes the Gulf of Tonkin resolution, and there are articles written, was there a second attack? There are books written, was there a second attack? And finally, about a year and a half or 2 years ago, there's an article in the New York Times saying that the NSA had an article saying that there was no second attack. But the article was classified, and it was in NSA, something like Cryptologic Review at the NSA. So I think after about 1 or 2 months, NSA just threw everything on its website. So I downloaded about 400 documents, and the article explained that there was a first attack. There were signals coming, not of a second one, but late ones coming from the first one. So we went to war in Vietnam on the basis of false information, just as we went to war the second time in Iraq on the basis of not just false information about 1 out of 6 claims of weapons of mass destruction, but all 6 claims false. So this is the danger of relying on the executive branch making claims, always hyping it up on the basis of information that's false. The last example on secrecy is the presidential daily briefing of August 2001. That was so secret that the intelligence committees had never seen them. Eventually, the 9/11 Commission got it and published it. Condoleezza Rice, as National Security Advisor, testified that it was just historical interest. In fact, as you read it, it talks about bin Laden intending an attack on the United States here, at home in the United States, using airplanes and with reconnaissance going on in New York City. Doesn't look like the administration ever did anything with that presidential daily briefing. I don't propose that it be published in the Washington Post or New York Times, but certainly to alert airliners and airports as to this danger. Keeping it secret left us defenseless. I think we'll get into discussion here. We had some great time this morning on extraordinary rendition. I have thoughts on that, another secret program. I want to talk about NSA surveillance and possibly secret legal opinions. Thanks very much.
Substance of your remarks, but I know that both of you could fill far more than 10 minutes with very enlightening information on this topic, and really do appreciate the restraint that you showed today in limiting it for now to 10 minutes because we want to get into some discussion here. And we're going to get some reaction from the other folks on the panel, and let me introduce them now. Most of you who've been coming to these conferences for years know that I have, for at least the last several years, always gotten the Friday afternoon panel slot. And it's always a challenge to make sure that people stay and stay interested. And one of the ways I've done that is that I almost always find a way to put Spike Bowman on my panel. Spike is currently the Deputy National Counterintelligence Executive, working for the Director of National Intelligence. But that's only the most recent of a number of moves in recent years and a very long and distinguished public career. He had been, just immediately before that, serving as Senior Research Fellow at the National Defense University. But for many years, those of us who knew Spike knew him as Senior Counsel at the Federal Bureau of Investigation, where he provided legal advice for national security investigations and agents wrestling with those issues and challenges. He began his career in intelligence in the Navy, in naval intelligence, and served as Deputy Assistant Judge Advocate General of the Navy for litigation. And we're very pleased, Spike, that you could be here with us again today. We've also got with us this afternoon Wendy Parker, and we're particularly pleased that Wendy was able to be here because Wendy is the Deputy Staff Director and General Counsel of the House Permanent Select Committee on Intelligence, and she has had very little sleep. As those of you who had an opportunity this morning to read the paper know, the House passed yesterday after a brief hiatus. They had brought it up previously and pulled it down and brought it back up again. Tomorrow, yesterday, the Restore Act to amend the Foreign Intelligence Surveillance Act, and it was, as you might imagine, quite a long and hard struggle, which Wendy was right at the heart of, and very relevant, obviously, to the issues we're talking about today. So we're really pleased to have you fresh from the front lines, Wendy. And David Criss, your program says that Jack Goldsmith is going to be on this panel, and unfortunately, Jack, at the last minute, was compelled to be elsewhere and really couldn't be here today, and he's really sorry not to be able to be here to participate, and let us know yesterday, at which point I immediately turned to David Criss with absolutely no notice, asked if he would be willing to step up to this panel because I knew that David could do it with no notice and with no preparation, because he's been another one who's been writing about and thinking about these issues for quite some time. David, after graduating from Harvard Law School, clerked for Judge Stephen Trott of the Ninth Circuit and then joined the Department of Justice through its honors program. He worked as a prosecutor for 8 years, from 1992 to 2000, and then from 2000 to 2003, he was Associate Deputy Attorney General, where he supervised a whole range of activities related to national security investigations and intelligence, including the government's use of the Foreign Intelligence Surveillance Act. He represented the Department of Justice at the National Security Council and other interagency meetings. He briefed and testified in front of Congress extensively, and he assisted the Attorney General in the conduct of oversight over the U.S. intelligence community. David has recently collaborated on a book, the National Security Investigations and Prosecutions. It's really more of a Bible than a book. It's a loose leaf so that it will be kept up to date, and it's really a terrific resource for all of those who are interested in national security investigations. So thank you, David, for pinch hitting today, and we're very lucky to have you. I thought we might start, Wendy, since you are fresh from the battle lines, having just passed this law regulating the President's authority with regard to domestic surveillance. And I want to ask you whether you think that in passing that statute, Congress was in fact engaged in law breaking.
No, Suzanne. I don't believe that in passing FISA that Congress was engaged in 1978 in law breaking, but rather sound law making. And I believe that, yes, the President does have inherent powers when it comes to certain things, including foreign affairs, and also, to a certain extent, the collection of foreign intelligence. But when that collection implicates the rights, the constitutional rights, including the Fourth Amendment rights of Americans, then I think that Congress does have a true role. And in passing FISA, Congress stated, and you can find it in the 1978 reports that accompany FISA, Congress stated its belief that it was not only concerned with the rights, it wasn't concerned with the rights of foreigners overseas, but instead it was concerned with the rights of the people who they may be in contact with, such as Americans, and the peoples whose communications may be picked up when the government surveils those foreign targets. So no, the answer is no, I don't believe that Congress was engaged in law breaking, but lawmaking rather.
We're going to talk, I think initially I'd like to stay in the realm of constitutional authority, and then I think we'll move subsequently to the policy discussion, you know, sort of putting, to the extent that you can, the constitutional authorities aside and what makes sense from a policy perspective. But Spike, you've written extensively about the Fourth Amendment in this area, and you were another one who was on the front lines advising agents in this and offering legal opinions. And if you'd like to take a crack at the constitutionality of FISA and Congress's authority to regulate in that area, and then I think we'll hear from David on that and then move to another area of congressional regulation of intelligence.
Okay. As Bob mentioned, there were several circuit court cases that had to do with the President's authorizations of wiretaps for foreign intelligence purposes prior to FISA's being written. Not one of those five, there were 5 cases, not one of them had the same opinion. And one of the things that I think was in the minds of the Congress and the Carter administration at the time is somehow we need to regularize this so that we know what the standards are going to be. Now, Congress was not at that time trying to say, Mr. President, you can't do this. They were saying, here's the way to do it so we have a standard. So I think procedurally, the FISA was constitutional. What bothers me a little bit is that they wrote the FISA, the statute, at a period in time when they knew what we were talking about. And the world has really changed significantly. Technology has changed, the threats have changed. But I think as far as the FISA statute being written at the time, it was a procedural mechanism that had nothing to do with the Constitution or the power of the President under the Constitution.
David, you know, it's one thing to analyze whether FISA, I mean, the abstract is a constitutional law, whether that is a constitutional exercise of the Congress's authority to pass such a law. Part of what we've been wrestling with, though, over the last couple of years is can it be unconstitutional if applied under certain circumstances? And maybe you'd like to
sure.
address that issue.
I think clearly FISA could be constitutional in many of its applications, even if not necessarily in all of its applications. And that's true of many laws at least outside of the First Amendment area. And indeed, at the time that it was being considered, there were some members of Congress who opposed the bill and some outside witnesses who opposed it. And the hypothetical that was traditionally deployed to articulate these objections and oppositions was the one in which there is clear evidence that there's a nuclear bomb somewhere in Georgetown, but we don't know where, and it's set to go off in 8 hours, and you have to do 10,000 wiretaps because the instructions for detonating the bomb are coming in by telephone shortly. And one member of Congress opposed the bill because he said, look, this is not exactly what he said, but it's the gist of it. He said basically that is going to result in 9,999 violations of FISA to do 10,000 wiretaps where only one guy is really the bad guy. So I can't vote for this bill. Everybody else sort of said, meh, whatever, we'll vote for it anyway, and it'll be okay. And Congress said when they wrote the bill, you know, we know the President might have power here, but we are asserting against that power, our legislative power, and he's supposed to follow FISA or not do the surveillance. But I think they recognized and said in the legislative history, look, if the courts disagree under the Steele seizure framework, then that'll be the way it is. So I think Congress understood at the time it enacted FISA that there might be cases where the President would violate the statute and would get away with it. I'm not saying they endorsed that by any means. They opposed it to the extent of their power, but they did recognize the reality.
So where does that leave, David, the exclusivity provision in FISA that I think is even stronger in the Restore Act?
I mean, I think the exclusivity provision puts you, and is designed to put you, in steel seizure category 3, the situation in which the president's power is at its so-called lowest ebb, where effectively, I mean, the president must follow FISA unless FISA is unconstitutional in unduly restricting some area of plenary that is sort of untouchable presidential power. I mean, in a way, that's the sort of less crazy-sounding way of describing what we're talking about today, which you could have said to your friends from the Czech Republic. It's not, you know, when does the president have to follow a statute? It's really, when is a statute unconstitutional in restricting what the president can do? I think analytically those are identical questions, but the second one sounds a lot more plausible than the first.
So let's try to explore a little bit where that realm of exclusive presidential authority might be, where Congress can't encroach. Certainly the argument has been made that electronic surveillance of, certainly electronic surveillance of Al-Qaeda, it falls within that realm because it is a context in which we are at war, and this is part of the president's commander-in-chief and war-making authority, and it is akin to battlefield decisions. It is akin to deciding where to send the troops and their sort of operational, those kinds of operational details. And most people would agree that Congress really can't interfere with that. Spike, do you think it is akin to, you've been in the military and in civilian service, do you think electronic surveillance of an overseas target is akin to a battlefield decision?
That's one way of looking at it, I think. I think the way I prefer to look at it, though, is that, as Bob mentioned, when FISA was written, the existing statute on wiretap said that nothing was intended to interfere with the president's inherent authority to conduct surveillance for foreign intelligence purposes. In 1978, when the statute was written, they removed that provision, and Congress made the statement at the time. They said that we have now occupied the entire arena of electronic surveillance with these two statutes. That's all there is in the world. And in 1978, I think that was correct. I don't think it's correct today. And therefore, the question, I think, becomes, has the character of the FISA statute morphed simply because of technology today? And to that extent, if a threat is recognized that the FISA statute does not cover, and you need a wiretap, a secret wiretap, in order to protect the American public, yeah, I think it is like a battlefield decision.
And then is there a time issue there? Is that authority then there indefinitely? If a circumstance has come up now that Congress clearly didn't foresee, where there is an urgent need in order to defend the nation to engage in electronic surveillance that falls outside the scope of the Foreign Intelligence Surveillance Act, you know, under the Keith balancing test, where you're balancing the government's compelling need against the nature of the privacy intrusion, does it make sense to consider as part of the government's compelling need that sense of urgency? And so over time, does that wane and does that balance then shift? And at some point along that continuum, have you fallen out of the constitutional framework of Keith?
Yeah, I think you start approaching both legal and policy issues here. Going back to the thought process of one of the thought processes for the FISA statute was to regularize the process. And so we do things the same way. The public knows what we're doing things, how we're doing things, have oversight of the whole system. So you talk about a continuum of time. I think time does factor into what's acceptable, not necessarily as constitutional matters, but what is acceptable socially for the American public. And that was a lot of what drove FISA to be created in the first place. It was a social issue rather than a constitutional issue.
So we've sort of talked about the authority of Congress to regulate electronic surveillance of foreign targets and the idea that the President may retain some residual authority there, and what is the scope of the Congress's authority. And I want to get into a little bit to try to tease out the factors that are at work as we analyze each of these issues. We've had discussion today about renditions, and we've had discussions today about enhanced interrogation techniques or torture. And both of those are sometimes justified, often justified, as necessary for intelligence collection. Can Congress regulate the President's authority with respect to rendition, with respect to interrogation, with respect to torture? Bob?
Yeah, I think one of the questions that I think needs to be asked, that I'll answer your question, but the question comes, where does the President get authority to regulate the collection of foreign intelligence? Where does Congress get this power? Now, Lou mentioned the case of Little versus Bareem. Little versus Bareem was a situation in which Congress had authorized the President during the quasi-war with France to seize ships going into French harbors. Captain Little seized a ship coming out of a French harbor. The Supreme Court said that exceeded the authority of Congress, even though the President ordered it, and therefore fined or ordered Little to pay a lot. Congress quickly reimbursed him for that, apparently disagreeing with the case. But Congress in Article 1, Section 8 has the power to regulate captures on land and water. That was a capture on water. That's an express power given to Congress, one of the exceptions that Jefferson and Hamilton and others talked about. On the torture case, Congress in Article 1, Section 8 has the power to define and punish violations of the law of nations. Violations of the law of nations include violations of the Convention Against Torture, the CAT, violations of the Geneva Conventions. Congress clearly has the power to make it a felony, to apply the death sentence if it wants, to torturing someone, to any other war crime. This is part of their turf. But Jefferson and Hamilton didn't agree about much, but both of them said the executive power gives the President complete control over foreign affairs, except for the exceptions specifically given to the Senate or to Congress, which were to be construed narrowly. And I don't see any language in the Constitution that says Congress is to have anything to do with intelligence, nor do I see, and we have specifically the Federalist Papers saying the President is left able to manage the business of intelligence as prudence might suggest, explaining Congress can't be trusted with secrets, so we have to keep them out of this. So, I guess the question I hope you'll ask is, where is the textual, a commitment to Congress of a power to seize the President's control over intelligence?
David, you want to answer
just one,
that question?
just a little question for Bob, and it's probably silly. I'm not really a constitutional scholar. In fact, those of you who are expecting Goldsmith have every right to ask for your money back when you, because you got me instead. Bob, there are obviously some powers enumerated in the Constitution that give Congress authority in certain areas, including with respect to the military, and the UCMJ is in large part based on that. What do you make of, the commerce power, which is clearly the power on which Congress formally relied in enacting FISA, which applies to both interstate and foreign commerce? Does that simply stop at the point it starts to impinge on foreign affairs, and if so, why?
Yeah, the Commerce Clause, since the 1950s, has undergone a great transformation. Anyone familiar with the Civil Rights Revolution and the growth of congressional power over state power in that area will be familiar with that. The Founding Fathers, I think, viewed that as a power to regulate trade. They did not view that as a power, well, it's commerce when we move troops from here to there or something like that. So Congress was intended to have narrow powers. The Founding Fathers were very concerned that Congress would usurp the powers of the other branches, and thus they debated how we limit powers. I mentioned Jefferson wrote this memo saying that the executive power is given exclusively to the President, except for the exceptions. Well, 3 days later, Washington wrote in his diary that he discussed Jefferson's memo with John Jay and James Madison, and they agreed with Jefferson that, quote, Congress has no constitutional right to interfere in the business of the State Department, save for those specific exceptions of a negative over a treaty and a negative over diplomatic appointment. So this was understood as an exclusive power by them. In the same way, in Curtis Wright in 36, the Supreme Court said, into the field of negotiations the Senate cannot intrude. Congress itself is powerless to interfere. Well, obviously negotiations could be described as commerce between the United States and its foreign treaty partners, but that was not the understanding of the framers. That's not consistent with the most cited Supreme Court case on foreign affairs, United States versus Curtis Wright. We keep talking about Steele seizure. If you read Steele seizure, Justice Black from the majority repeatedly says this is an internal domestic case. Justice Jackson, who 2 years earlier in Eisentrager had cited Curtis Wright for the proposition that the president has exclusive control over foreign affairs, repeatedly said we're not limiting the president's power concerning the external world. This is an internal affairs case. This was a case where the president instructed Sawyer, the Secretary of the Interior, to seize the steel mills to avoid a labor strike. And this was a Fifth Amendment case. The Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law. The president wanted to seize private property. He didn't have due process of law. And Lou Hinken, in his classic Foreign Affairs in the Constitution, says Curtis Wright has not been considered a foreign affairs case.
Lou?
Go ahead, Lou. I think the other case.
Lou, I know you wanted to jump in.
Yeah, three points on steel seizure. I've heard Bob say this before. The steel seizure was a domestic case. Of course, Truman wanted the steel to prosecute the war in Korea in the middle of a war. Secondly, on Curtis Wright, the language Bob just gave about negotiation being a field into which the Senate cannot intrude. Of course, that's 100% dicta, had nothing to do with the case at hand, and the person who wrote it, Justice Sutherland, when he was a senator, wrote a book in which he said, of course we're involved in negotiations. So there's a complete disjunction between the practical life of Sutherland as a senator and what he was writing for some reason in dicta in that. I wanted to make a third point that one way we could relieve a little bit of the difference on the panel members is that, as Spike said, there was a constitutional basis at that time in 1978 to this extent that technology and threats change. You can amend it, and FISA has been amended a number of times, including after 9/11. But there's another point. There's something called Lockean prerogative, where an executive is able to act in an emergency for the public good, not only in the absence of law, but against the law, and then you come to the legislative branch, as Lincoln did, to get retroactive authority. So I think from what's been said on the panel members here, there may be, as David said, there may be situations of such unusual nature that an executive or president has a right to act inconsistent with the law under the understanding that the burden is on him to explain why he acted as he did, and then to go to the legislative branch. So I think we can make exceptions to that process.
Wendy, Bob was seemed to be making a distinction between a domestic situation, domestic activities, and foreign activities, foreign affairs activities, activities overseas. And I wonder how you see that playing out in the FISA context. May I go back to your opening point about where the focus for FISA really is, not so much on the overseas target, but on the potential communication inside the United States, and how you see that playing out in that framework.
Right. If we go back to FISA as it existed before the Protect America Act, there is clearly an exception built into FISA that when you're collecting purely foreign communications and there's no substantial likelihood that you'll pick up a communication of a U.S. person, then it's okay to engage in surveillance without a warrant. Similarly, but I think FISA is different. And again, I'm just going back to my earlier point. Even today, members of Congress who have been engaged in the creation and then the final passage on the House side of the Restore Act, as well as those who have been engaged on the Senate side, have often talked about, what FISA means and tried to explain it and what it actually does. It's a complicated statute, but to say the least. But the bottom line is that FISA is not designed to address those purely foreign communications. Instead, it talks about collection here in the United States. It talks about collection against United States persons. It talks about those things that relate to the rights, the constitutionally protected rights of Americans. And so again, I would say that this is not purely a foreign matter. Furthermore, I think that it's clear, I think most of us would agree, that intelligence and intelligence-related activities that are carried out by the executive branch are designed to ensure that our national security is protected, to support and assist the armed forces, and to also support the president in the execution of foreign policy. And again, just going back, I'm not a constitutional scholar either, but Article 1, Section 8 of the Constitution is a section, is something that we cite annually in our intelligence authorization bill, because we have to justify why we're engaged in our authorization activities. So we have a constitutional authority statement. And basically, and I'm paraphrasing Article 1, Section 8, Bob has talked about Congress having the power to regulate captures on land and water. But in addition, it also addresses that Congress should have, or also states that Congress shall have the power to pay the debts and provide for the common defense and general welfare of the United States, to raise and support armies, to provide and maintain a navy, and to make all the laws that shall be necessary and proper for the carrying into execution all the powers that are vested in the Constitution, or by the Constitution, in the government of the United States, or the departments or agencies and officers thereof. And I think that that's an important point. Congress believes that this is carrying out the necessary and proper clause of the Constitution when they regulate in the area of FISA as well as other areas, and not impinging on or infringing on the power of the executive and the power of the president as commander-in-chief.
So, Bob, Wendy cites the Fourth Amendment and the language that she just read as providing Congress with authority. You cited the Fifth Amendment that was operating in the steel seizure case and was really what was at issue and therefore justified Congress acting. You talked about the authority that the Constitution provides for Congress making laws with regard to capture, for example. And so would you say, at least with regard to the sections that you cited, that if Congress does exercise its constitutional authority to regulate in that arena, that the president needs to comply with that law?
10 seconds to the footnote to the last point, and that is, I forgot to mention the most important thing. In Jackson's concurring opinion in steel seizure, he footnotes Curtis Wright, and then says, but that case is not useful here because it draws a distinction between internal and foreign affairs. In other words, he's saying Curtis Wright's not useful because this is not a foreign affairs case. Now, to this issue, a few things. First of all, the language giving the common defense and general welfare language was not a grant of power to Congress. The grant of power was the power to tax, to impose. When you read the whole clause, it says you can tax for the purpose of promoting the general welfare and providing for the common defense. There's long statements by both Jefferson and Madison when somebody suggested, oh, the general welfare clause means Congress can do anything it wants that it thinks will promote the general welfare. And Madison was outraged, and he said, we spent months sitting around the hot summer in Philadelphia in 1787 debating the narrow powers to be given to federal Congress. It's absurd to think that we would then say, oh, by the way, they can also do anything else they want to do that they think might promote the general welfare of the country. Jefferson made exactly the same point. The necessary and proper clause, 2 words, necessary and proper. Proper excludes seizing the powers of another branch. You can't use a necessary and proper clause to say that Congress can pass a law telling the Supreme Court it has to decide cases as directed by a committee of Congress. That's a usurpation of constitutional power. It's not proper when you're taking the powers of another branch. And it's, every executive, every president has liked FISA. I liked it. Why? Because it solves a problem. If you engage in foreign intelligence surveillance, You can't be sure if you find evidence of a crime that the evidence is going to be admissible. If you go through FISA and you have a court order, there's no risk of that. That's why every president has liked FISA. But in wartime, where we can also argue the AUMF, the authorization for the use of force, is a subsequent law that has authorized the president to conduct war, and certainly gathering intelligence on the enemy to know where he is when you want to attack him is one of those fundamental incidents to war, like the power to detain enemy combatants. If you go back to the Hanby case, Justice O'Connor upheld the power of the president to detain U.S. citizens, even though there was an express law, the non-detention law, that said no U.S. citizen shall be detained by the government except pursuant to law. And the Supreme Court said, well, when you go to war, you detain enemies, so that gives the president the right under that statute to do this. So I think the case for the president in this case is even supported by the latest law, except if this one is passed. But go ahead.
Yeah. Well, Justice O'Connor, in that same decision, of course, I think made it very clear that that decision was limited to those circumstances which involved a zone of active combat, someone who had been detained in a zone of active combat. And she went on to talk about those traditional understandings under the law of armed conflict, in the context of a war that might go on indefinitely, where the enemy is ill-defined, that those traditional understandings may begin to unravel. She also talked about how whatever authorities that the Constitution reserves for the President in international affairs and foreign affairs and engaging with other countries, she said surely it reserves a role for all three branches when it comes to the rights of U.S. citizens. And I wonder, again, sort of trying to tease out some of the factors that are relevant here, what is the legal relevance when we, in this context, in the context of this discussion, of accepting the framework of the global war on terrorism, so that intelligence activities outside of a zone of active combat, let's put Iraq and Afghanistan to the side, and now in the broader context of the global war on terrorism, how significant is that in finding residual presidential or exclusive presidential authority to act in contravention of U.S. law? David, do you want to?
I'll try. It's a pretty tall order. I mean, I think, first of all, I'm not totally clear that the government accepts a distinction, or at least not a hard distinction, between Iraq and Afghanistan and the continental United States. I think I have seen some assertions, and I'm not sure how seriously they're meant or where they'd be applied, that, you know, the U.S. is the battlefield, and I'm sort of thinking of the Padilla case as the main vehicle for expressing that point of view. So I'm just not sure that that distinction is fully accepted. I think the implications of not accepting it are potentially far-reaching, but they are what they are. I mean, I think, you know, I guess maybe this is a question for Lou, and then there's a flip side of it that might be a question for Bob or people who are lined up in those camps. I mean, could the Congress enact a law that says there shall be no foreign intelligence surveillance, either in the United States or even abroad, period? And I mean, I think that's a way of getting at whatever inherent authority the president has that can't be impinged upon. And for Bob, I guess the flip side of that question is, I guess would be an invitation to distinguish the steel seizure case from, say, the TSP, the terrorist surveillance program, because there's a surface analogy between the two, right? Yeah. Steel seizure case, foreign war, domestic seizure of steel. TSP, foreign threat, but one end of the comm is in the U.S.
Very good question. Lou, go first.
Let me respond to what David said. I'm very uncomfortable about opening a door to inherent powers for any of the three branches. We have express powers. We have implied powers. You can tease out of express powers certain implied powers. You have to do it that there's a reasonable basis to draw them out of it. You're still working with the Constitution. As I said before, I think there's a third category of emergency powers where you might act in the absence of law, even against the law, and then come to Congress. I don't want to say anyone has inherent powers, because no one in this room, including me, has any idea what we're talking about, inherent powers. You say it's inheres in the office or inheres in the person. Nobody knows what that means. And so you really, once you go in that direction, you're giving up the Constitution, you're giving up the rule of law, you're giving up checks and balances. So we do have opportunities. As far as David's question, I mean, that's not only a hypothetical, but something Congress is not good judgment, but it's not going to do that. You know, and are there limits on both sides? Sure, and then you can fight it out through the regular political process. And I also think making it much more difficult in terms of rule of law and the Constitution is when you not only set aside FISA, but you do so in secret, and you do so with secret legal opinions to justify it. And then you're off the map.
Let me try that too. You don't want me them to hear this, do you? I know. The terrorist surveillance program, there are parallels. It is, in fact, let's talk about the TSP. Okay, the TSP, what we know about it, first of all, New York Times, 14 December 2005, had an expose, and it said, we are intercepting NSA is intercepting communications, electronic communications, between foreign known or suspected terrorists outside this country and unknown people, presumably inside this country. Now, should we have a higher standard for wiretapping Osama bin Laden during time of war, where he's trying to kill as many millions of Americans as he can, than we have for, say, white-collar criminals? Our FBI expert here can confirm that when the FBI gets a regular law enforcement wiretap, it has a legal right to listen not only to that person, but to every other American citizen that person talks to on that call. They have minimization requirements to protect the rights of those people, but if Lou here on his side is selling drugs, and they've got a wiretap, and I call up and say, I want to buy a couple of kilos of something or other, they can prosecute me with that thing without the slightest warrant to listen to me. My rights are what you might call
But they do have a warrant on Lou.
They have a warrant on Lou. They have a legal right to listen to him, but not to me, and my rights are collateral damage, basically. Now, I just was doing some research on this issue earlier this week. The average federal wiretap warrant intercepts communications from more than 100 people, most of whom for which the government doesn't have a warrant. Why? We still say you can copy that, it's collateral damage. Now, everyone agrees that it's not only legal, it's part of the president's duty to try to intercept Osama bin Laden's communications when he's in Pakistan. If he emails or calls his best friend in Afghanistan, that's absolutely core commander-in-chief power, it's absolutely core executive power. And the question comes, if bin Laden decides to communicate with someone in this country, should we have to unplug the headphones, to use an old metaphor? And that's absolutely ridiculous. If he's talking to someone in this country, he may well be telling him where to get the explosives to blow up the Lincoln Tunnel or the Renaissance Hotel in Washington. We want to be listening to that. And yes, that may mean we'll wind up intercepting a communication from an American who sold a lamp on eBay to Big Tall Arab at AOL.com and is asking him where to ship the lamp. That's all right. You know, that's just collateral damage. In war, you have collateral damage. But if we go the other way, and if you say, well, if bin Laden communicates with some unknown U.S. person, you have to unplug the headphones or send the FBI agents around to identify that person, track them around, see if they can get probable cause for a warrant, you know, what is the cost going to be on that? Now imagine, I'm bin Laden's lawyer for a moment. I'm going to tell him, anytime you want to communicate with your agents in the United States, here's what you do. You use the copy line, and I'm going to get you the names of 13 94-year-old ladies living in old folks' homes who still have AOL accounts and may check them every 6 months, and we're going to call this email Cheap Mexican Viagra. And we're going to have 2 pages about, well, we haven't really tested this except one guy died, but we think it'll work and it's really cheap. Would anybody in this room read past the 2nd page of that email? No. And so by having that U.S. person, we say, oh, well, the FBI's got to go investigate Mrs. Smith down there in Dallas. It takes months before we finally get to look at that email and find out bin Laden has told someone to blow up, I shouldn't say blow up the UN, because maybe that would not be a negative in the eyes of everyone here, but let's say blow up the Capitol building or the hotel.
Fortunately, Bob, as you said in your opening remarks, we really haven't heard anybody suggest that, you know, what they really need to do is unplug the headphones. But we have seen a very serious and I think largely thoughtful debate in Congress about where those, how do you protect the Fourth Amendment privacy rights of Americans while still meeting the national security imperative for electronic surveillance. But Lou, you wanted to say something.
We're still on FISA, so the way it worked out, as you know, that during that period of time when it was secret, there were consultations, briefings with the so-called Gang of Eight. I think that was improper. The Gang of Eight was for covert operations where you're trying to affect the economy or political structure, social structure of another country. So this was not a covert operation. I think that was a wrong model to draw from. And the Gang of Eight only includes the leadership and the intelligence community, whereas the judiciary committees, they have jurisdiction over federal courts and FISA, so they were never in the loop, the judiciary committees. And then the last point on the procedure used, not only did they brief the Gang of Eight, but they briefed the chief judge, and there were 2 chief judges in a row on the FISA court. And I think that was improper because FISA court must know that the FISA statute, the essential element, was to have an external independent check on executive action. So for one judge of the FISA court to be briefed and not to let the other 10 judges know so that they can make an independent judgment as to what role they have, what legal role they have. So I think that whole procedure, both the Gang of Eight and briefing the chief judge of the FISA court, was improper.
David, we touched briefly, but I want to come back now to the issues, other issues than FISA, the rendition and torture, and we all are familiar with the memo of August 2002, which talked about, first sort of laid out very clearly this theory that if when you're interpreting laws, that if you try to engage in constitutional avoidance. I think it was an unusual interpretation of that doctrine of constitutional avoidance, but the way that it was spelled out was if you're looking at a law and it would be unconstitutional if applied to restrict the president's authority, in this case to conduct aggressive interrogation or what might be considered torture, that you should read the law to avoid that constitutional conflict, and therefore you should read it as not applying to the president in that context, and therefore the president can't engage in that activity without violating the law or pursuant to constitutional authority. And that memo also contained other language about defining torture in ways that caused quite a public outroar and was ultimately repudiated, but it was really that latter part, not the constitutional theory laid out in the memo. In fact, there were some statements at the time that the constitutional theory in the memo was not repudiated. And I wonder if you can speak to the sort of those issues around the president's unilateral authority in those areas.
Yeah, I can say something. I mean, I think that there's a couple of questions that come up when a statute comes to the president and he doesn't care for it. I mean, I think the first is you have to decide that avoidance doctrine is either a judicial restraint theory or really a proxy for legislative intent. I sort of see it, and I think the cases see it as a proxy for legislative intent. The idea is that Congress wouldn't write a statute that is unconstitutional unless it gave you a strong signal that it was doing so. So in the absence of a clear signal, you presume that it is constitutional, and you avoid the constitutional question in your interpretation. And you also presume that an act of Congress is constitutional, and that's sort of bound up. I think the president, just like the courts, would normally do that. He would presume constitutionality and interpret to avoid unconstitutionality where possible. The only exception to that, I think, is if Congress makes clear, no, we are taking the constitutional bull by the horns here. We do mean to pick a constitutional fight and don't avoid the constitutional question for that reason. And I think in that scenario it would be much harder to deploy avoidance doctrine to reach a narrowing interpretation and save the president the trouble of having to say it was unconstitutional. So, I mean, I think the president does approach it and should approach it the way the courts would. And obviously that will be influenced by his sense of how much power he has that can't be regulated.
One of the issues that arises once you accept the notion that there may be some circumstance under which the President can sort of unilaterally determine, or some circumstances, let me back up, in which the law would be unconstitutional if applied to restrict the President in some way, raises the issue of then who gets to decide that? And is it a decision that is appropriate for the President to make unilaterally? And there's a Justice Department memo, I think was written by Walter Dellinger when he was in the Justice Department, so it goes back a number of years, that talks about the President's authority to not follow unconstitutional laws, and talks about the factors to be considered, and raises this particular concern when it's done in secret, when it's an area that requires particular to be kept in secret, because what is left then is political accountability, is the check on that presidential authority to decide not to follow the law. And obviously where it's done in secret, it very much diminishes the prospect for accountability. It also very much diminishes the prospect for accountability in the courts, for someone to bring that issue to the courts. Spike, you must have confronted that in your time in the Justice, at the FBI, and I wonder what your thoughts are on that. Who gets to decide, and how do we make sure it stays within bounds?
Well, I think the President gets to decide that. He's constitutionally charged with protecting the American public, so he's got a responsibility, not just a right, that is involved here. The real question, I think, though, is the one that you posed earlier, is the continuum of events. Unquestionably, in my mind, the President has the right to take whatever an action he thinks is appropriate to protect the American people. The question is, then devolves on how long can he continue this action? Does he need some other branch of government to support him? What is the next step? And those are facts that are going to that are being dependent on whatever the situation is.
And Jack Goldsmith, if he was here, would have much to say on that latter point, and I commend to all of you, if you haven't read his book, The Terror Presidency, that you do so, and that will help a little bit to ease the loss of his presence here today. But he writes very eloquently about the policy side of this, and the reasons why, aside from what the Constitution might mandate, why the President might be wise in going to Congress to get support and authority even after the fact. And he talks about the example of Lincoln, he talks about the example of Roosevelt, taking actions that they then came to Congress and said, I think I may have exceeded my authority here, and I want you to bless it, and in doing so, became more powerful from a political perspective in doing that. And Lou, I'm going to give you the last word before we open it up for Q&A from the audience, which I hope has been sufficiently provoked by this discussion.
On the signing statements, when Congress passes a bill that the President considers unconstitutional, there are some other options that are constructive. And I think of the one in 1943 where Congress, in an appropriation bill, put in language saying that you will not give money to these three named people who we consider crackpot and communists and subversives. And President Roosevelt didn't want to veto the appropriation bill, but he did in a signing statement say he thinks that it is an unconstitutional bill of attainder, and it was litigated and went to the Supreme Court and was struck down on that ground. So there are some good, constructive, clear things that can be done to keep unconstitutional things from being binding.
Do we have any questions? Yes.
Leaving aside the criminal aspects, but focusing only on the intelligence aspects, isn't the discussion about FISA much ado about nothing, where we can outsource our intelligence collection against American citizens through operations such as Echelon or other intelligence sharing operations with our allies, and where they can provide us as much or more than we would get were we to do it directly ourselves?
Is that aimed at anybody in particular, or just a grab? Spike.
I've got about a half a dozen different answers. I'm just trying to think of one that won't make everybody wrong. I'm happy. First of all, you don't know what echelon is, so I'm going to discard that one. Okay, and I'm not going to explain what echelon is, by the way. We do have prohibitions that on our asking someone else to do something for us that we cannot lawfully do ourselves. So that is part of our law. It's part of the oversight mechanisms for the intelligence community. It's the sort of thing that IGs and general counsels are charged with looking at. We also have agreements with countries around the world that you don't spy on us and we won't spy on you. We won't intercept your calls. You won't intercept ours. So there's what you're suggesting is we could enter into this big intergalactic conspiracy, I guess, to do this, and when in fact we really couldn't do that sort of thing, not only from our own laws but from the reaction of every other country in the world.
Bob?
Yeah, I completely agree with Spike. One of the points the Supreme Court made, and it was dicta, just as entire Marbury versus Madison was dicta, in Curtis Wright. In Curtis Wright, the Supreme Court noted that every constitutional power has to be exercised consistent with the rest of that instrument. The president cannot indirectly, find some sidewind, to use the Jefferson language, to violate the Constitution if he can't do it directly. And in the same way, I would argue that when Congress, as it's done thousands of times, passes conditions on appropriations, telling the president where he can put troops or how to fight a war, or as Bob Dole did, telling him you can't have money for the State Department if you don't move the embassy from Tel Aviv to Jerusalem, those are unconstitutional conditions. You can't do indirectly what you're prohibited from doing directly.
Speaking of dicta, Bob, there are those who would argue that the statement in the FISA Court of Review opinion saying we take for granted that the president has this authority was also dicta.
Yeah, it's not a ruling on that, but it was a unanimous declaration by the court that Congress had violated the Constitution, which is of some value.
Judge Everett.
As best I can recall, there's some provision in the Constitution that speaks about declarations of war. I don't think we've had a declared war since World War II. We probably will never have another. What significance does that language have, one way or the other, in interpreting the powers of the president and the powers of Congress?
I don't think it's significant. In the two cases I mentioned, 1800 and 1801, we're both on that point, whether you needed a declaration to go to war against France or the authorizations were sufficient. The Supreme Court said either way, authorization or declaration would be constitutional. Some people say that a declaration somehow is an announcement to the whole nation to use the full powers against an enemy. But legally and constitutionally, they're equivalent.
I agree with Lou that Congress can authorize.
We agree.
Bass versus Tingey and Talbot versus Seaman both made it clear that Congress can authorize something less than all-out war. But more importantly, I would argue the power to declare war today is as much an anachronism as the power given in the same sentence to grant letters of marque and reprisal. Congress had the power to grant letters of marque and reprisal, which was to authorize privateers to take their private ships out into the ocean and do battle with enemy warships or seize enemy cargo ships, sell the ships and their cargo as prize, and a prize court would award the money by a fixed weight. The captain, the owner would get the biggest pot, the captain the last first mate, the cabin boy would get a couple of six-packs or something. This was all very regularized, but the world community outlawed letters of marque and reprisal in 1856. And thus, if Congress wanted to violate international law and issue one today, I guess it could do it. Similarly, if you study the history, remember, as Hamilton said in his first Pacificus letter, the power of Congress to declare war was an exception to the general executive power granted to the president, and that should be construed strictly. The power to declare war, that's a term of art from the law of nations. all the great writers that defined this, Grotius, Vattel, Burlamaqui, they all defined this as something associated with aggressive war. If you are at peace and you decide to launch an all-out war against another country, to seize part of their territory, to force the king's daughter to marry your son, whatever, you were supposed to declare war. And they all said you don't declare war when you're acting defensively. Under the UN Charter, under Kellogg-Briand, the 1928 treaty that outlawed aggressive war, the world community has said you can no longer engage in that type of war. Now, if we decided to do it, if we decided to launch an all-out aggressive war against Canada, Congress would have a veto. But for the most part, that clause is an anachronism today, but Congress still has tremendous power because the commander-in-chief has no military to command unless Congress creates it. He has no money out of the Treasury to spend unless Congress gives it to him. There are lots of very important checks in Congress, and as a policy matter, I strongly agree with Spike and others that and with our missing friend from Harvard, that the executive ought to consult regularly with Congress. I was acting Assistant Secretary of State for Congressional Relations in '84 and '85. There were people in the State Department who thought I was nothing but an apologist for Congress because they would call me and say, the president has decided to do so-and-so, is going to announce it Friday, you need to consult with the Hill. And I would, in a rather angry voice, say, I can't consult with the Hill. I can inform them, I can notify them. And had you told me about this 2 weeks ago, I could have gone up and talked to Sam Nunn and a few other people and maybe gotten some very good ideas and maybe built some goodwill. But you can't come to me the night before a decision and say consult about a decision that's been made. If Congress will behave itself and won't leak secrets, which it does these days so routinely, and it has throughout my adult life.
I'm going to take exception to that, Bob.
Well, that's all right. We can do that. We can spend a conference talking about
I actually
leaks.
think Congress's record is very good, and particularly congressional staff, at keeping secrets and not leaking information. Members sometimes misspeak. Some members sometimes misspeak, but Judge Everett, I think your question about declarations of war again takes me back to a point that I think is particularly relevant and to this discussion and to the broader discussions that we've been having at this conference again, and that is, who gets to decide that we are operating in the context of a war with all of the legal authorities and implications of that, the potential skewing of the checks and balances in favor of the executive, sort of generally the deference of the courts and Congress, in addition to triggering the Commander-in-Chief Article 2 authority, not to mention all of the statutory authorities that fall in, that are triggered when we're at war. And having, from a policy perspective and a very practical perspective and pursuant to international law, having moved away from congressional declarations of war, we're now operating in this arena where it's not at all clear who gets to make that decision. Yeah.
We're talking about the FISA court, which is one of our first forays into a secret court. It may not be our last. Are there any lessons from the experts up here who deal with this, our national security courts, which are discussed in the brochure we have here, and other sorts of discussions that we may have? Are there any lessons from FISA, which is this experiment that we're quibbling about a lot of technology, but it's really a pretty big step for us from open courts to closed courts. Is there any lesson we can learn from that we ought to think about in the future?
Wendy, would you like to take a stab at this, having looked, and thought a lot over the last several months, particularly about the advantages and disadvantages of putting these decisions about electronic surveillance in front of the FISA court and the role of that court, the potential pros and cons of a national security court?
Right. Well, with respect to the FISA court, I think, a lot of people have been very skeptical about what occurs behind the closed doors. But I think overall, from what I know and from what we've been told, and based on our interaction with the FISA court and others at the Department of Justice and FBI and NSA, the FISA court is very balanced because it recognizes that it has the judges recognize they have a heightened responsibility given that, the proceedings are not adversarial and that they're done in secret. and that their opinions and decisions and are not, and their orders are not, made, subject to public scrutiny. I think that in both the House version as well as the Senate version, for instance, of the FISA reform bills, and on the House side it's called the Reform Act, of course, you'll see something that talks about en banc authority for the FISA court to sit en banc. And this is something that is supported by the court. This is something that's supported by members of Congress, and the executive branch doesn't object to it. So I think through the course of, going through FISA and finding out what's needed in this area, we've learned, a lot about the FISA court and what the needs are. With respect to a national security court, we haven't, I personally haven't focused on that much. But I think there are, if it's able to proceed in the same way and operate in the same way as the FISA court, I think it probably wouldn't be a bad thing. But again, this would be a huge step.
Spike, maybe you're in a good position to talk about this, having, again, worked within the, and then David, I'd love to hear your thoughts as well, both of you having worked within the criminal justice system and very closely with, prosecution of terrorists in our normal criminal justice system, but also both of you very familiar with the way that the FISA court operates and the sort of pros and cons there in terms of public confidence, et cetera. Maybe you can speak to this.
Yeah, I've been agonizingly familiar with it. I would say that, well, Bill asked a very good question. Are there lessons that we can learn from the FISA court? And I think there are a lot of lessons, but let me lump them into three categories. The first is that I think we've found that we can conduct a secret court with sufficient oversight that the protections that we expect of a court in the United States are there, they're available, and they're there for a select number of people to see, but those select numbers include inspectors general, general counsel, include the Congress, includes the President's Foreign Intelligence Advisory Board. So I think we've learned that there is a process that we can do, and we can have confidence that it's right. The second flows from that. I think that we've also learned, those of us who have been on the inside of this, we've learned that we've built a very, very clumsy and difficult mechanism, one that requires a great deal more elbow grease to make work than is really necessary or is appropriate, I think. And the third one is the hardest one for me. When FISA was created as an electronic surveillance statute, the only electronic surveillances we were carrying out were the hardwired telephone and the microphone. As we move forward, you all use all of the new gadgets that are electronic today. And leaving aside what the FISA statute says for how you do things and what the definitions are, we have 11 judges who have a day job. And they come in once a week, or one of them comes in every week to sit on the FISA court. And we're asking judges who are senior judges who have only seen Title III wiretaps up to this point in time to come in and understand what it is they're being asked to do. And I think we actually are unfair to these judges by not preparing them, taking them away from their day jobs for whatever the time is necessary, and teaching them what modern technology is like, how it works, what's going to happen when you hook up machines to different types of things. Because I've had judges that have not understood at all how it works, and it's not their fault. We haven't built into the system the tools to help them.
David?
Yeah, in responding to that question, I think it's important, well, let me at least distinguish between sort of whatever mechanism or statute is set up that describes the duties of the court and the way the court functions. And I think I want to say something nice about the FISA court, because they've had some mean things said about them lately. I think that the evidence shows, first, that the FISA court can keep secrets. There's no evidence that I'm aware of them leaking anything. So the security concerns that were articulated in 1978 I don't think have amounted to much. They do keep it secret. Second, I think it's pretty clear, at least to me, that they're not a rubber stamp, despite the ex parte nature of the proceedings. The FISA court, in its only published opinion, ruled unanimously against the government in the aftermath of the Patriot Act and had to be taken up on appeal. And Judge Lamberth, the former presiding judge, has described publicly in a speech at the University of Texas, I think, a fairly robust back and forth process that occurred even in the absence of the entry of any formal or many formal orders of denial. And Jim Baker, who until recently was the head of OIPR, has made a similar description in a Frontline interview. So they're not a rubber stamp, I think. And third, I think they've shown that they can do the math or chop the wood that is put in front of them. That is, the standards in the statute can be applied with the caveat that Spike mentions, which is that the workload has gone up dramatically. In the first year for which statistics were kept, I think they had less than 200 FISA applications. And in the most recent year for which statistics are available, they had more than 2,000. So the court's expanded from 7 to 11 judges, but the workload has gone up too, and the complexity of the issues has also increased. So I think going forward, that would be the area to consider. I think they keep secrets. I don't think they're a rubber stamp, and I think they will do what they're supposed to do, but it's getting pretty hard.
Spike and David, do you think that there, and Lou, I know you want to get in here, do you think that in the context of a national security court, that the issues that that court would be wrestling with are more complicated, more complex than issues that the courts wrestle with today in the corporate context and in lots of other contexts in which they're asked to address very technical or detailed
It's no
issues?
worse than a cocktail of ERISA and the tax code in Chinese.
Lou?
Yeah, there's to me, a big difference between a FISA court where you're getting an order versus a national security court where you're going to get a judgment against someone, often in the context of preventive detention. And the discussion so far about a national security court would have to be mapped out, would certainly have lesser procedural rights than you would in a regular Article III court. So there's a world of difference between a FISA court and a national security court. Bob just said he agreed.
I do agree. Let me raise just one point. This committee every now and then singles out a national security lawyer who's really made an exceptional contribution to the country. One of the people that was never recognized, passed away many years ago, was a woman named Mary Lawton. Mary Lawton set up, or she actually was the second head of OIPR, the Office of Intelligence Policy and Review, but ran it for many years. The reason the FISA court has been called a rubber stamp is because during all those years, the court never turned down a case because Mary Lawton was absolutely brilliant and absolutely dedicated to making certain that no request ever went before, no application ever went before that court that was not absolutely clean. And so the court, you know, with people like Mary Lawton and Spike Bowman, who ran the FBI National Security Law Unit for many years in their general counsel office, you know, from my perception, you don't need the court. The court then becomes the rubber stamp because the job has been done. But because you know, when planning for posterity, we ought to remember that virtue is not hereditary. Maybe someday somebody running an office will not be a Mary Lawton or a Spike Bowman, different offices. But Mary really deserves the gratitude of this entire country, because in so many areas, when I went into the Reagan administration to oversee intelligence, Mary was the only Democrat they allowed to stay, and everybody respected her so much. You know, she was the person you called if you had any doubts, and she's been dead for several years, but she really was a saint in this area and made a tremendous contribution, and all this silliness about this court being a rubber stamp is a consequence of the fine work she did in staffing the request.
Thank you for that reminder, Bob. Okay, we've got a question over here.
Thanks. Harry Pullman, Dickinson College. In coming to grips with this tension between looking at executive power as an exclusive power to collect foreign intelligence information versus Congress's power to regulate a wiretapping based upon whether it's commerce power, necessary and proper power, or perhaps Section 5 of the 14th Amendment, sets Congress's power to protect liberties. Would the panel be willing to comment on 2 points? First of all, if it is an exclusive executive power, does this mean that the President would have the power to engage in purely domestic wiretapping if high executive officials would certify that it is being done for foreign intelligence collection purposes? And this, of course, makes it much, much broader than simply al-Qaeda. And secondly, if Congress does have the legislative power in this way, why wouldn't Congress have the power to impose burdens on the executive's power to collect foreign intelligence information for the simple reason of protecting the Fourth Amendment rights or the 14th Amendment rights of Americans abroad?
It's a good question. It's a hard question. I think the easy answer is that in the view of the Founding Fathers, the President would have that power. Remember, George Washington, as General George Washington, authorized the interception of every letter we could get our hands on coming into the United States from Great Britain, opening, reading that letter, and then carefully resealing it and sending it on its way so we would not lose that source of intelligence. You know, every president in wartime has authorized intercepting all international cable traffic. Lincoln authorized tapping the telegraph wires to get messages going back and forth. The tradition of this, the history of this, is the president can do that if it's foreign intelligence. If it's domestic intelligence, the Supreme Court has said you have to have a warrant. Now the question is there a possibility of abuse? And the answer is yes, there is. But it's much less than it was in the 1960s. Why? The Inspector General's office at NSA has more than 100 employees. There are IG offices throughout. You can't do these things by just having 2 or 3 people involved. And if the president were to say, hey, I want you to listen to Ted Kennedy's telephone calls or John Kerry's telephone calls, that would be in the front page of the Washington Post within hours, and it should be. So, yeah. There are possibility, one reason the president has these powers, or 3 reasons: secrecy, speed and dispatch, unity of design. Talked about frequently in the Federalist Papers and in Elliott's debates of the state ratification conventions. We have a lot of horrible mistakes that are made in war. We fire a missile to hit an al-Qaeda safe house, and we instead hit an orphanage or a place where a wedding's going on or something like that because we had bad intelligence. And if we followed the normal due process and had the intelligence agent or the soldier come back and appear before a court with evidence to support his decision, we might avoid some of those risks. But of course, 3 months later, when the soldier got back, he might learn that those al-Qaeda guys have gone out and killed 2,000 people in the meantime. And so you have to accept a certain amount of collateral damage. You are going to get, remember the case I gave you earlier, every federal wiretap on average intercepts the communications of more than 100 innocent or at least Americans for whom they don't have warrants. It's perfectly legal to listen to al-Qaeda, certainly in wartime. Why do we say, when we're trying to stop a catastrophic terrorist attack, that we're going to impose a higher standard than we do in protecting the rights of Americans when they happen to communicate with a white-collar criminal or a drug dealer or something like that? It just, to me, it makes absolutely no sense.
Well, I think one of the interesting aspects that I think is highlighted by your question is the blurring of the lines between foreign and domestic intelligence and the difficulty often today of making that distinction. And certainly you can conceive of, with the concern about homegrown terrorism, where you might have what is otherwise a purely domestic intelligence collection activity, whether it's surveillance or other collection activity, but it's for the purpose of foreign intelligence because you think they're inspired by what they've seen on the internet in international commerce. And David, I wonder if you could talk a little bit about where we go with that issue. How significant is it, the foreign aspect versus the domestic aspect, and in that context, how do we draw those lines and make those distinctions?
I have no idea, but I know it's a big problem. I know because I just wrote a long sort of paper wrestling with this, and I do think that one of the problems we have today is that foreign persons, there was non-U.S. persons located outside of the United States, can communicate with one another inside sort of U.S. cyberspace. on the servers of an American ISP if they're exchanging email. And that, I mean, I think in a nutshell is sort of the vexing problem that everybody is sort of struggling with. Is how do you deal with the idea that on the one hand, you have non-U.S. persons located abroad with no connection to the United States other than the fact that they signed up for a free account at Hotmail. And on the other hand, the fact that if the government wants to go after their comms, they're going to be rooting around inside American servers of U.S. ISPs in which the vast majority of users are actually Americans in the U.S. And I think if you sort of play that out over and over in your mind, first you get slightly nauseous, and second, I think you sort of get at the nub, I think, of why each side is looking at the other one with puzzlement and befuddlement today. And I'm not sure I have the answer, but I think that at least is sort of one way of describing the problem.
Spike?
Yeah, David has stated it very well. I think I think if you go back to the Keith case that Bob mentioned earlier, Justice Powell was looking at the same type of an issue, and he gave us what is perhaps the only guidance that we have in this area when he said that judges of the United States courts are perfectly capable of looking at common crime in the United States, but he said we offer no opinion as to what the situation would be were the individuals involved agents of a foreign power. And that in itself is a very difficult problem to root through, because if you're looking at criminal activity, you know, you've got something sort of tangible to look at. If you're looking at who is an agent of a foreign power, you're looking at mental intent, and that's very, very difficult. But as between the issues, if you think about domestic terrorism and foreign terrorism, you've got the same issue on harm. The only separation of the two is the mental intent of the two sides. And Justice Powell, I think, said, I can't solve all of the problem, but he says, here's what I would suggest, and that's what was adopted by the Congress in the FISA.
So would you, using the hypothetical that I gave of the, homegrown terrorist who has never traveled outside the country, never met with any foreign national, but who is, been reading stuff on the internet and is now inspired to join the cause and carry out an attack. Is that an agent of a foreign power?
I would not be able to demonstrate that to the court under current standards. That's, whether it's an agent of a foreign power would depend on revising your standards.
But the standard set by Congress in FISA was very careful to say, we're not talking about people who attend meetings of the group or fellow travelers. You have to be, the standard is you have to be employed by or take orders from the foreign power. And in my view, the example you gave, that's purely internal and would require a warrant under Keith. It was one of the points I wanted to make.
So it's not really a question of whether you're hoping to collect something that would fall under the definition of foreign intelligence. It really turns more on the nature of the target.
Well, if you're talking about a target that got inspired by some foreign behavior, but is purely domestic and is not communicating with them or something like that, I think that comes under Keith, and clearly you have to have a federal, judicial warrant for it.
Yeah, and the Keith case itself was Justice Powell recognized that the reason he was drawing that distinction is because if you're talking about agents of a foreign power, then it's the executive branch, the president, that has to deal with whatever that foreign power is.
Foreign affairs.
If it's domestic to the United States, we've got 900,000 state and local police officers who can deal with it.
If you're interested in that case, by the way, Dean Jeffries of UVA Law School has authorized the best biography of Lewis Powell, and he talks at length about Powell's views on this issue. Powell worked on an ABA committee that concluded you did not need a warrant for the Fourth Amendment for a foreign intelligence intercept, but you did for a purely domestic intercept. One last point. We're told, it's classified I guess, but it's been in the papers and Congress has confirmed it, the FISA court has said if bin Laden sends an email to his number 2 in Afghanistan and that goes through a switch in the United States, that is covered by FISA and we can't listen to it. So we have a serious problem here.
Of course, being covered by FISA doesn't mean you can't listen to it. It means that you have to go through a certain process before you can listen to it. But do we have additional questions? Yes.
Yeah, I have a question for Wendy Parker. Suzanne raised before the issue of some of the ramifications of calling this struggle, I guess, that we're in a quote-unquote war on terror. And it seems to me one of the most important ones has been the impact it's had on the conduct of covert operations, in the sense that the military, specifically special operations forces, are doing a lot more of them. But one of the ramifications of that is that they've said that because they're in a war on terror, then now they're exempt from notifying Congress of these operations under the traditional military activities exception. And I'm just wondering if HPSI or any of the members in particular are looking into that issue, and if you're trying to do something about that seeming loophole.
Yes, and actually, in a conference report, an intelligence authorization conference report issued years ago, the conferees did address that issue. The members of our committee don't really care whether or not it's conducted, an activity is conducted by the military. If it is done, if it's an intelligence activity and it resembles a covert action activity, then it should be reported to our committees. The executive branch under the National Security Act has the duty to keep Congress fully and currently informed of all intelligence activities. And therefore, we believe that if those activities are carried out by any branch of the intelligence community, which include intelligence elements of the military, then we have the right to know about them. And so, and also, I would add that the National Security Act of 1947 also states that the mere fact or the mere fear that information may be disclosed or revealed by Congress or others is not an excuse for keeping information away from Congress. We've heard some suggestions that that might be an excuse for doing it, but in fact, the law says it is not. So yes, there is that concern, and that's why our committee is engaged in, I think, pretty vigorous oversight of the activities of not only, your traditional executive branch agencies such as CIA, who have covert action authorities, but also the military side as well.
Okay, I'm getting the high sign from Richard that we've neared the, or at the end of our day here. It is, Bob always gives us such a wonderful historical perspective, taking us back to the very founding of this nation, to remind us that this is a debate that has been going on since the founding of our nation. It is a debate that continues very much, obviously, today, and it is one we will continue to have, and I actually think it's one of the great strengths of our system. So I hope you will join me in thanking our panelists for participating in this debate and discussion today, and thanks to all of you.
Well, have you had fun? Bear with me for 2 minutes. I want you to help me thank some people who really made this all possible. The University of Virginia Center for National Security, Professor Moore, its director, we thank you so much. Bob Turner, thank you so much for your recording and videotaping and for your information. We'll have a lot of the video and the taping available on our website, so you can check that if you would like. A special thank you to Donna Gano, the administrator, and Kay Wood at the Duke Law Center on Law, Ethics, and National Security. Its director, Scott Silliman. Thank you, Scott. And a particular thank you to all these law students who ran these microphones around the room. Thanks, guys. To the National Strategy Forum and its president, Richard Friedman, and its communication director, Lauren Bean, and to the members of our Standing Committee on Law and National Security for the American Bar Association, we thank you, particularly Laurie Kroll, who ran our CLE desk, and if you still need information on that, it is outside. To Brian Knight, our staff assistant, and to our absolute superstar, Holly McMahon. Holly, thanks. Holly still has a sign-up list for if you're interested in our breakfast meetings. We hope to crank those up again next month, and we would invite you to join us, and again next year for our 18th annual review. And a final thank you to yourselves for coming and participating and being with us. And may, on behalf of the committee and myself, I want to be the first to wish you on the great American holiday, Happy Thanksgiving.